Let's start, because we've got so much that we want to talk about. This brilliant book, Bodies and Evidence, Race, Gender and Science in Sexual Assault Adjudication. So welcome, my name is Joanna Bourke. I'm Professor of History at Birkbeck, but I'm also the director of the SHAME project, SHAME standing for Sexual Harms and Medical Encounters, and we're the one hosting this launch or the celebration of this book. Before I get to our speakers and, of course, the authors, let me just do some housekeeping. Just to note that the event is going to be recorded, but you won't be recorded. The speakers only will be recorded, so you don't have to worry about turning your cameras off or anything like that. Speakers will be recorded, but not the audiences. There is closed captioning and live transcription available. Also, please, the chat in the far right of your screen, I think it is, please pop any comments, pop any questions there into the chat bar. I will be picking them up during the Q&A, which will take place in the final 30 minutes of the event. This is a really, really important part of these events. So please, we want to hear what your ideas are, what your thoughts are, what your questions are. So pop them in the chat and I will pick them up in the last 30 minutes. Here's a little advert. If you purchase the book through NYU Press, you can get a discount. And again, in a few moments, the discount code is going to be popped in the chat. The event that we are participating in, of course, we all know it refers to sexual violence. This may cause distress. You would have sent, attendees have all been sent a link to our safeguarding statement ahead of time. But, please take care of yourself. You can find that safeguarding statement in the chat. But, if you need just to go out, have a breather, have a cup of tea, whatever, come back in, whatever you want, please just feel free to do it. We are going to be live tweeting this event. So if you're on Twitter, please feel free to share your thoughts and tag us at SHAME, that's SHME, _ BBK, which stands for Birkbeck. So that's all the housekeeping. I now have the great honor of introducing our 5 speakers. The 2 authors, I'll start with the 2 authors of this really amazing book. Sameena Mulla, she is an Associate Professor of Women's Gender and Sexuality Studies at Emory University, which is in Atlanta, in Georgia. She works on intersections of legal and medical approaches in US interventions into sexual violence, in the ways that these are sort of invested in regimes of gender, race, and power. In 2014, when I first became aware of her work, she published a really interesting book called The Violence of Care: Rape Victims, Forensic Nurses, and Sexual Assault Interventions, which I also recommend to you. So she's one of our authors. The second author is Gethin Hlavka. She is an Associate Professor in the Department of Social and Cultural Studies at McKee University in Milwaukee, Wisconsin, in the US. And she works on sexual violence against children and against youth, including some really interesting work on, well, I found it really interesting, on text messaging evidence in court, on embodiment, on stigma, on shame, and intersectionality. And then we have 3 discussants, and I'll just introduce them in the order that they will speak. The first one is April Petillo. She is an Associate Professor of Public Sociology in the Department of American Ethnic Studies at Northern Arizona University, where she does some really interesting work on sex trafficking of Native peoples, on legacies of chattel slavery, and sexual violence interventions in Native communities. Then we're going to hear from Gabriela Torres, who is Professor of Anthropology at Wheaton College. She's a cultural anthropologist who specializes in the study of violence, particularly gender-based violence, and of course, and on state formation. So the work of hers that I know most is her work on sexual violence in intimate and marital relationships, on mandatory reporting and state violence in Latin America. And then we have Gethin Rees, who is a lecturer in sociology at Newcastle University in the UK here, who works on the intersection of healthcare and criminal justice, particularly looking at healthcare professionals who work in police stations and in prisons, and sort of scientific and medical evidence presented during criminal trials. And he's published really widely on sexual and scientific knowledge, visualization techniques in forensic contexts, and the role of the expert and anti-rape technologies. So, I mean, we're going to have a really, really rich discussion here. Welcome. We're so thrilled that so many of you have come to participate in this, I think, round table, we can call it. I've discovered, we have participants from a huge range of countries. So welcome. People from the UK, the US, Canada, New Zealand, Australia, Netherlands, Norway, Ireland, South Africa, and Jamaica. Really welcome, and we're really thrilled to see you here. But let's get the whole thing started because you don't want to hear from me. First, can I pass over to Sameena and Heather? Can you just tell us how you came to write this book?
Thank you so much for that introduction, Joanna. Heather and I are really excited to discuss our work today and to hear from the panelists who are scholars who've all really influenced this project over the years and whose work I hope we can all engage with. Before I start, I'm speaking to you from Atlanta, Georgia, and Heather is in Milwaukee, Wisconsin in the United States. And rather than offer a kind of formulaic land acknowledgement, I'm just going to put into the chat an interesting article about land acknowledgements and what we hope to achieve with them from that was featured in the newsletter of my professional association as an anthropologist. And I will say that one of the things that Heather and I seek to learn from our Indigenous colleagues and scholars is in fact the way law itself has really become a source not of justice, but of repression and dispossession, and continues to be into the contemporary moment. And we take those lessons very seriously and don't relegate them to the past, but rather think of them as part of the present. So thank you everyone for joining us today. And also being committed to hearing, reading, and addressing the oftentimes challenging and upsetting narratives and nuances of sexual violence in our cities, communities, and our homes. And thanks especially again to Joanna Bourke and Rhea Sukhdev Singh and Alison McKibben for bringing this event together. We'd also like to thank Amber Powell, who's here in the attendees I see today, who's our former research assistant, for her considerable contributions to this project. She is also a scholar to watch out for. We are very grateful to be in conversation with Joanna and Gethin Rees and Gabriela Torres and April Petillo. So in Bodies and Evidence, Race, Gender, and Science in Sexual Assault Adjudication. Sorry, the title is still so new to me that I stumble over it. What we argue is that adjudication itself sustains and shapes knowledge and experience of urban space, of criminality, of race, sexuality, and poverty, and reproduces the very cultural narratives upon which the courts rely when they're prosecuting these cases. And we show in the book that these processes subject whole communities to carceral discipline and constitute sexual, gender, and racial inequalities. As we will discuss in greater detail, scientific and nursing expertise are among those discourses mobilized in the service to these practices. So for those of you who are unfamiliar with Milwaukee, which is the location of our study, it's the largest city in Wisconsin, which is the 5th largest city in the Midwestern United States, and follows Chicago as the 2nd most densely populated metropolitan area in the Midwest. Wisconsin has incarcerated over half of the Black men from the city or from the county of Milwaukee. and thousands from central city Milwaukee neighborhoods have state prison records. So I want you to pause with that, because to have half of any one community to have experienced incarceration at any one point really creates a very particular location, ecology, and set of conditions by which people are struggling to make a living, to be in community and to be in family formations. The Milwaukee County courts are situated in this local landscape and history, and it's into this fray that we located our collaborative study on sexual assault adjudication procedures. We came to this work after each independently completing projects that examine the role of forensic intervention in survivors' experiences, either as patients or as clients embedded in state systems. Thinking about the role of forensic intervention and technology in sexual assault interventions, we wondered how this was shaping sexual assault adjudication in later criminal legal prosecution stages. Heather had studied the role of forensic interviewing in children's disclosures of sexual violence, while I had completed an ethnographic study of a hospital-based sexual assault forensic intervention program. Now, we were aware that a growing body of research suggested that forensic evidence had little to no impact on criminal case outcomes. So there's a glut of literature that essentially shows that the inclusion or exclusion of forensic evidence does not suggest how the case will be processed or proceed. We can't predict the outcomes based on that. But because it didn't seem to be related to the outcomes, we wondered what became of the forensic interviews and DNA evidence that was laboriously corrected from hundreds of clients and patients. How did it change the process, and how are these expertise actually being used in criminal courts, and why? So starting in 2013, we spent over 18 months observing what ended up being over 688 court appearances. And these appearances included 34 full sexual assault trials and over 100 sentencing hearings and other proceedings, which we documented in our field notes. We also acquired and analyzed a small subset of the official court transcripts, 22 complete trial transcripts, and 54 sentencing hearing transcripts. And you can imagine that official transcripts and field notes actually show a lot of slippage between what makes it into the official record and what does not. We also interviewed judges, attorneys, forensic scientists, jurors, sexual assault nurse examiners, and victim advocates. We've designed this project as a collaborative ethnography grounded in feminist praxis, blending together both anthropological and sociological methods. Part of our feminist praxis means thinking with intersectionality, focusing on various ways in which our research participants are impacted and rendered vulnerable in the world of the courts, and also valuing the multiple standpoints that are drawn together in this practice of fieldwork by the team itself. For us, it has meant finding an ethical way to also include defendants within our research, to take seriously questions of racial prejudice and the role it plays in sexual assault prosecution, and to question what forms of justice unfold in a courtroom, what claims are made about these forms of justice, and to whom they apply. After we left the courts and began the work of poring over our field notes, interviews, and trial transcripts, we also developed a descriptive practice to center the spectacle of the courtroom itself and not necessarily the spectacle of sexual violence. In short, if you were to pick up the book, you would find that there are very few descriptions of assault in our work. And those that do make their way into the text are a result of long conversations, discussions, and deliberation. While the text argues that the court's practices reify a cultural narrative of rape grounded in a scientific, racialized, racist, and sexist foundation, we also hope it offers insight into how one might cultivate a language and an analytical approach to sexual violence that rejects the unspeakability and, by extension, the unthinkability of sexual violence. And I'm going to turn it over to Heather now.
Thank you. We thought it would be a good decision to go through the chapters of our book very briefly on bodies and evidence. And we organized our chapters around the most typical order in which sexual assault trials tended to unfold in the court, beginning with jury selection and ending with the defendant's testimony. We adopted the trope of the trial as a structure with the intention of orienting readers to the truth-telling practices of the trial, which are experienced as cumulative, fragmented, and sometimes even contradictory. Each chapter reveals the many forms of legal storytelling that ultimately reproduce rape myths and narratives that rely on racist, sexist, and classist tropes. Throughout the book, place matters, and we show how these narratives are invoked in relation to local landscapes and histories in Milwaukee. Chapter 1 examines the most common ways in which attorneys introduce jurors to ideas about sexual violence, trauma, forensic evidence, issues like credibility, prejudice, and fairness. Anticipating the testimony to come, then, attorneys situate the cultural narratives as they frame their theories of the case. Jury selection was both a formal procedure to vet jurors on their presumed impartiality, as it was an opportunity to assess jurors' cultural commitments to matters relating to the case. Most cases we observed opened with the testimony of the victim, called the complaining witness or the alleged victim in the courts. Thus, Chapter 2 opens with an examination of the voices of victims in the context of the trial, demonstrating the distinct approaches defense attorneys took to discredit the testimony of women, children, and adolescents. The spectacle of the victim witness testimony unfolds at the intersection of gender and race. In Chapter 3, we then examine the role of the police witness. Here we show how law enforcement take on the dual roles of fact and expert witness. And we also attend to the gendered labor of policing and the challenge courts face when it is the police who are accused of sexual assault. In Chapter 4, we turn then to a handful of cases in which sexual assault nurse examiners took the stand to argue that the trial draws on medical legal imaginaries and expert knowledge to construct the rape body, largely to explain the absence of evidence. The nurse engages heteronormativity and discourses of virginity, reproduction, birth, and ableist frameworks of masculinity. On the rare occasion that DNA is collected, its discovery requires the testimony of forensic scientists. And thus, in Chapter 5, we examine how the DNA analysts present forensic evidence to the jurors. We explore the performative techniques of expert self-presentation, the deconstruction of statistical probabilities, and taken for granted interpretations of DNA identification and race. While it is rare for defendants to take the stand, in Chapter 6, we examine the narratives of and about defendants. We argue that many defendants resist the prosecution's efforts to cast them as criminal by tapping into the powerful cultural role of the father, particularly as it intersects with race and class. Fatherhood can be framed as grounds for leniency or as grounds for punishment. We end our book by widening our frame of analysis to draw out the tensions between the forms of harm that the court recognizes as legible and those it does not. Centering the marathon testimony of one woman, we show how the jury is asked to rely on their knowledge of local geographies and the common sense knowledge of people and communities living in the city of Milwaukee, clearly demonstrating the processes of criminalization and objectification of victims and defendants, their families, as well as their neighborhoods. And with that, we look forward to hearing from our wonderful panel and the audience during today's conversation. Thank you so much.
Great. Can I hand over to April? Do you want to take?
Sure. So I want to start by saying I'm a visitor to the traditional territories of Native peoples in what's now called Flagstaff, Arizona in the US. And this space includes or touches on Ne, Dene, Havasupai, Hohoko, O'odham, Hopi, Hualapai, Pueblos, and Shawina territories. I'm also witness to the continuing impacts of colonization and the genocidal processes of forgetting. And I teach to aid in radically honest remembering. These ancestral homelands are also the current home of a diverse, vibrant group of these Native peoples' descendants. I recognize that acknowledgement alone is a small gesture that only becomes meaningful when actively coupled with authentic relationship and informed action. It's my wish that this acknowledgement encourages all of us towards informed action. And to help do so, I'm posting now to everyone links or information about Native Land Canada, as well as landback.org, which can help you identify the traditional territories that you are currently in, as well as potential actions that you might engage to establish or build or continue that authentic relationship and informed action. The next thing I want to say is, one, thank you so much, Sameena and Heather, for the incredible engaging work that you have created. I want to say birthed, actually, because even as you read it, it's a long process that it's obvious that continues. It has a legacy that carries on. And I say legacy in the best way possible. And I want to acknowledge and appreciate your refusal to participate in these spectacles of suffering that are usually required by the criminal justice system, as well as the process of reiterating those spectacles in academic study and scholarly work. It is often hard to get people to pay attention to these conversations without those spectacles. So thank you. I recognize the commitment it takes to do that. And I also appreciate your turn to examining, instead of the harms that are exacerbated and newly created by legal processes, to focus on that instead of these spectacles. That committed look at the everyday practices is really something that we're encouraged not to do. So one of the things I hope in our conversations that we get to talk about a little bit more and that you address is what it means to sit in the skin that you're in and pay attention to and be witness to these harms that are created by these processes, and how that informs not only the way you might look back at past work and this work, but future work as a scholar. I'll put out there that for myself, oftentimes the things that I think through in my own work that sort of parallel or I believe cross with some of the work you've done here in Bodies and Evidence, and I actually have the book here with me, is I think about what I call the tyrannical connections between statecraft and carcerality and our roles within these processes, and how that then creates these erasures around gender, sex, sexuality, and violence that are reinforced by this idea of a neutral or objective or rational process, usually, as you skillfully point out, that are connecting medical processes with legal processes. Then connected to that, the way that these mark specific bodies as consumable, and that work of the spectacle. And one of the things, or some of the things that really kept coming up for me as I read through this book, were thinking about this sort of state-sanctioned disregard for human beings and for the experiences that means even when the state has a lack of resources, as you point out, what happens is these consumable bodies that are witnesses for the state become they become the tool or the mechanism that needs to adjust instead of adjusting the system. And that the court procedures, especially the use of technology and science, then becomes a technology for these processes of harm, the creation of the spectacle, and is given more value than the experience, than the actual human beings that are there engaging in what you've argued is a form of public humiliation in many ways in the court. and then subjected to sort of proving themselves as valuable in the face of all of this scientific, technological information that's seen as more objective when, as you've pointed out, it's highly racialized, highly gendered, highly invasive, and in some ways sexualized in a particular way. So for me, as someone who's thinking about tyranny and statecraft, all of this comes back to the needs of the state and how we, as people who are supposed to be benefiting from this reiteration that we need the state to protect us and to ensure justice, how are we then complicit in that? And what I know what we say the responsibilities of the courts are, but what are the responsibilities of determining value in this context? And how does that relate directly to the ways that gendered professional performance as experts, for instance, shows up and define what we accept as true or not true? And how does the erasure of rape victims, people who are always already flawed, to borrow a phrase, people whose value originates in being complainants, not for themselves, but for the state, require broader community complicity with a carceral state? The other thing it brings up for me, which I think you wonderfully and eloquently sort of conclude the entire piece with, is thinking through, is it even possible for us to live feminist ideals and think through this and still have a carceral state? So could we ever really envision a world where rape culture is not so prominent if we insist on relying on the carceral state? So I promised I would keep it short. Those are some of the thoughts in my head, and I look forward to engaging around that and with that more with you all.
Thanks so much for such a powerful statement, which we will need to return to at the end, because, I mean, this is what the book really does, I think, extremely well. Gabriela Torres, do you want to come in here?
Absolutely, it's my pleasure. I want to start with an acknowledgement that I'm situated on the traditional territory of the Wampanoag. For me, this is an acknowledgement of the active processes of erasure of Indigenous peoples' history, their forced removal, genocide, and theft that is continuing of their ancestral lands. I want to thank Sameena and Heather for writing this inspiring volume, and Joanna for hosting us today on this book talk in the Shame Project. There are a number of issues that are raised by bodies in evidence for me, not just in terms of work around sexual violence and how it comes to be represented in courts, but actually very specifically because for the last 10 years, I've been working on gender-based violence cases in U.S. asylum courts. And doing this work in practice, being part of court processes and writing court narratives, really, there was sometimes so much that was excited in terms of what they were describing in a very different court system within the United States that reverberated, that I had to put it down and I had to say, oh my goodness, how is it that in very different courts this comes to be replicated? And what does it mean that there is replication of the same processes for shaming for disciplining and conscripting experiences in courts that actually compel participation. And perhaps the courts that I work in, the participation is so compelled that it's a life and death participation, right? And so I kept thinking through all of that while reading the volume, and I want to offer remarks on three areas. The first is the way that legal processes reproduce and sometimes challenge key conceptual categories. So Bodies in Evidence talks particularly around ways that race, victimhood, and gender are reproduced, and it does throw so as threads amongst the different chapters. This is done through the process of jury selection. It's also done through the expertise testimony, and it's also done through fact-based evidence, right? The way that fact-based evidence comes to be included, such as DNA evidence. In my work on asylum, this replicates, right? It replicates very clearly. When I think of specific ways in which it does, around issues of rape. So in asylum, who gets raped, the gender of the person who gets raped, in many ways determines the effectiveness of rape to prove their sufficient victimhood to actually warrant an asylum, a positive asylum determination. And simply by whether or not a person who is being raped is cisgendered female, if a person who's being raped in the asylum system is a cisgendered female, that actually really makes their rape kind of insignificant to make a positive asylum claim. And for anyone who's gendered otherwise, rape actually can be seen as a way to actually cement their harm as a harm that is useful for the purposes of creating a positive asylum claim. So here you have an example where an explicit experience needs to be crafted in different ways to actually replicate US-based scripts of gender. Right. And so thinking about their work and the level of specificity that that Heather and Sameena's work had actually brought me to really high levels of specificity in my own work. So a question around this issue. So given the complicated interplay that there is between law and the social cultural context, for me, there's a little bit of a disconnect in that people come to the law still, despite much evidence to the contrary, that the law is a place where we can gain justice. And for asylum seekers, in my case, the law is a place where you can get protection, right? So justice, protection, is still an expectation of the law. But if that's not the law in practice, in the practice that has been analyzed, then what of the law? What is the role of the law? What is the role that the law actually doing? And here I get to my second point, which is courts as sites of risk. So there's much that has been written in literature on courts as amplifying risks of sexual violence. And this is something that's not just in literature and discussed in different ways, but it's also in popular culture, right? That the re-traumatization of court process for victims of different forms of sexual and gender-based violence. In my work in asylum courts are definitely an unquestionable site for harm right? If an asylum determination is negative, a person is returned to the site in which the listing of harms, the narrative of harms that they have to present in court as evidence will continue, right? And so the arbitration of the harms by experts, such as myself, which participates in these courts, the attorneys and the judges, right? The arbitration of the harms actually has the explicit potential to create another harm, right? I think in bodies of evidence, that's also clear, right? How participation has an additional harm. And I think what's helpful about this work and where it adds to the literature that is existing on this is in its specificity again. Like it actually tells you the how-to is the harm caused, right? Often many studies will tell you that people narrate harms. This volume actually tells you the how-to, how was the harm caused from beginning of process to end of process, right? And I think for persons who have undergone processes of court determination for harms like these, it will be a very helpful way to understand those experiences. And I think it will enrich scholarship in very clear ways that way. And that takes me to my very last point, which I will be very brief with, and that is narratives. So there are different kinds of narratives discussed in the volume, different kinds of stylistic narratives that are all aimed towards an argument, right? There are sequential, staggered narratives that are aiming to further a specific argument, right? Whether it is a prosecutor's evidence or whether it is a defendant's evidence, they both are narratives that both or the multiple narratives pursue specific arguments. And as such, they have a specific structure, right? So experiences that we see expressed in court are highly structured. So one of the questions that I have is, to what extent are the structures that are compelled in the narratives that are presented in courts actually creating much of the problem, right? It's the fact that we are in this criterial logic where arguments are compelled and where the narrative styles themselves come to be compelled so that they can effectively pursue arguments. Is really deterministic. So I want to thank you for getting me to think in these ways, and I will pass it on to Gethin, I think.
Hello, everyone. Huge thank you to the Shane Project for inviting me to speak at this event, and thank you to my co-panelists for already such inspiring and thoughtful comments, and of course a huge thank you, which I'll probably continue to say throughout the next 10 minutes, to Heather and Sameena. There is so much I can say about this text that I've decided I need to actually present something a bit structured myself. And so I will turn to some notes that I've produced. So I want to begin by thanking Heather and Sameena for an exceptional book. You draw together your previous contributions and extend them with this fascinating yet heart-wrenching collection of cases. You provided us with a portfolio of new evidence and analyses to expand and develop in areas that many of us have been exploring for quite a while. For instance, the fluid and constructed nature of expertise, the way this dialogue between fact and opinion evidence that gets played through across multiple chapters, and there's never seemingly a crisp delineation between. It's absolutely fascinating to read. There's simply too much I want to ask you about, but in fairness to the audience and my co-panelists, I will try and limit myself to 3 interrelated areas. So it's clear throughout the text of the weakness of reformist approaches to criminal justice and in this area. Although Anglo-American jurisdictions have attempted to make women safer in courtrooms, the case studies keenly illustrate how it is the victim survivor, not the perpetrator, who is on trial and is the focus of the case. Rape shield laws, removal of corroboration requirements, other attempts to remove bad character evidence with regards to sexual matters from being presented in the trial have not stopped. And these are continue to exactly be the ground on which the criminal trials continues to be fought. And this might be a sort of smallish point or a sort of mundane point to pull out, but I think it's worth reiterating, particularly for some of the arguments that come out later in the text. From the voir dire, the witness, the jury selection processing, all the way through till sentencing, it's the acts of the victim survivor that are at heart and the focus of the court. And it's worth reminding ourselves that the cases that were being observed by Heather and Sameena were actually the cases that, for the criminal justice system, were the most likely to receive a positive outcome, i.e. a conviction. And so what about the cases that never made it there? And with all the contestation that has already been highlighted by my co-panelists, about the victim survivors' appearances, their character expenses, these cases are the cases that we are presented with continue to be the most winnable or successful cases in criminal justice's consideration. So with all of that contestation and the kind of narratives that we keep returning about what constitutes a successful case, how vague, how difficult are some of the cases to put forward. And, I'm not promoting the trial as a good thing, and we'll come back to the spectacle of suffering that I think is key to the main argument of this text. My point about the weakness of legal reforms relates specifically to questions of corroboration, which is key to this text. Heather and Sameena make explicit throughout the work that the work being done in the courtroom is the work of corroboration. Experts are retelling the victim survivors' stories in ways to make it appear more credible. It is also the case that forensic professionals, medical experts specifically, have played a substantial part in reinforcing and reproducing the nomos of rape. And as Heather and Sameena note, the production of cultural norms of sexual violence were disciplined through the scientific. I want to push the authors a little further on this point, however, and wonder whether there's in fact a cyclical relationship between forensic medicine and the nomos of sexual violence. Is it that the forensic expert's authority and legitimacy is a product of them being able to provide material evidence that conforms with our cultural expectations of victims in the first place? Is the nomos, has it been historically, I suppose I'm arguing, that the medical professionals were able to produce evidence that conformed with our pre-existing expectations about survivors, which granted the medical experts legitimacy and authority to speak credibly in the first place? And what we now see happening through the production of justificatory evidence towards negative signs, what I've referred to as neutral reporting, what Heather and Sameena talked to about this justification work and explaining evidencing negative evidence or justifying negative evidence. The fact that the healthcare professionals or the SANEs are now unable to rely upon the authority of signs of injury, are they feeling that they're potentially precarious? I think the quotation from one of the SANEs in the text spoke specifically to a sense of precarity in their role. Is it now the case that they want to start talking specifically about distress and to provide objective signs of distress, the amount of pain a victim survivor claimed to be in during the forensic intervention, as a way to try and provide a more stable ground on which to base their expertise? I found the fact that SANES nurses wanted to speak to the distress of the victim survivor fascinating, as in Scotland, where a specific corroboration requirement still exists, so evidence does legally need to be corroborated, distress serves as a particular form through which corroboration can be achieved. Is it the case that SANEs here are finding ways to provide their own tools for corroboration through distress and are mobilizing distress as a tool to get for corroboration for their own purposes of feeling less precarious? I found this an absolutely fascinating dynamic, and I would love to hear from the authors further on this. Finally, I wanted to return to the conclusion, where I felt the authors did an absolutely fantastic job of pulling together the various threads of the book and look forward to a feminist and transformative praxis, fundamentally challenging the reformist attempts and demonstrating the process of the trial in and of itself necessitates suffering, and choosing to avoid any substantial discussions with restorative practices that others working within this area have focused on. Rather, the authors, from my reading of it at least, seem to focus on a more prevention approach. And I was reminded here of some of what Joanna Bourke has talked about rape-free worlds as well, that this is a sort of preventionist approach. I was also reminded of Sameena's earlier work, where she identified the ways precarity produced multiplicities of harm. So I recall one of the respondents in her earlier text talked about the way the sexual assault was the third worst thing that happened that week within other nexes of harm and precarity. And so what produces harm is the subjectivities of the person and their situated selves and their situated lives. And actually what I see Heather and Sameena trying to do here is to look more broadly at the social, cultural, economic situatedness of persons, and to focus on ways of pulling people out of poverty, etc., as ways to produce a rape-free world, and not just the reductionist focus on GBV. Overall, I found this a thrilling and important book, and I would really like to thank the authors again for their important work. Thank you.
Thanks to all three discussants. That was really incredibly rich. We have some questions in the chat, but before we get to the questions in the chat, can I just pick up on a few of the things that were mentioned by the discussants? I mean, I'm really, and apologies if I don't pick up on everything. So if you want to add, if the discussants want to add something that I've forgotten, please just hop in and do that. I mean, there were questions about the whole ethical dimension of the actual project itself. In terms of, you established very early on in the book, and indeed in your talk here, that this was a feminist-led intervention into the whole field. But I mean, clearly there are really big ethical dilemmas that you would have had to struggle through when you engaged on this project. And I'm wondering if either of you want to say something more about how you grappled with those issues when you were starting the project, and indeed when you're finishing the project. Particularly, by the way, my own particular interest here is about interviewing defendants, but you can interpret the question however broadly you like.
Heather, shall I start, and then perhaps you can chime in? Well, I think the analysis we came to in the book, we really came through after doing the field work and after years of sitting with the material. So I think when we started the project, some of what we were grappling with was what it meant to do this kind of work. How we would protect people's confidentiality, right? Which I know is quite basic. We were in an open court for which we did not need permission to be present. Anyone could walk in or out, including at the time, if there was a 4-year-old child testifying on the stand, which was the reality of the courts that we were in. And I think the very first layer of our kind of ethical choice was collaborating and working together, so that we would have another scholar whose judgment we trusted, not simply for, I think a lot of times people think, oh, sexual violence is a really heady research topic and one needs the emotional support. But I'm a huge proponent that collaboration actually enriches the quality of the work, right? Enriches it methodologically in the sense that we could be two people, sometimes more, because we had these research assistants, including Amber Powell, with us oftentimes in the courts, right? In the same space, observing things, checking against each other, sort of debriefing live, but also ethically. Is this okay? And initially we had decided that we would use the names of the defendant because they're also known publicly. And, very quickly we realized the majority of the cases that we were observing involved people who knew each other, and oftentimes they are kin. And so if we were to name the defendants, then it would, very quickly become the case that everyone's identity would be really obvious. But I will also say that over time, we also began to be concerned, of that initial willingness to name defendants and to not regard the privacy that they might be due. So you'll note that we don't interview any adjudicants who participate in the trial. Sometimes attorneys, yes, court officials. We did oftentimes speak to family members or friends in the gallery because we became known faces to them. Sometimes they would check in with us and ask, hey, when is it going to start? We seemed to be neutral spaces. We could direct them to the people who, had the official information, but oftentimes we were less threatening. And these would be both families of people being prosecuted and participating in prosecution, and families participating in the defense. And I think some of the choices about not interviewing victim survivors, not interviewing defendants, right, also have to do with the idea that this is compelled testimony. It's not as compelled as the context Gabriela is talking about, right, in an asylum case. But you are a witness of the state, including the victim witness. It is the state's case. And we had seen cases where arrest warrants were issued and people were brought in to testify against their will. And you could be held in contempt of court and immediately imprisoned if you didn't participate. And so when your speech is being compelled in this space, the question is like, how extractive might the ethnographers be if we then go, chasing down the hallway and saying, hey, would you speak to us? So we made a choice, right? And making that choice means also understanding that there are going to be particular limits to what kinds of stories and narratives we can draw on in terms of our work. So I'll pause there.
And, if it's okay, I'll just briefly add, thinking about your question about the feminist ethics of our work. I think deliberately that was a feminist ethic of care for us. And oftentimes we talk about, as feminist researchers, we might, social scientists, we might come in and really think about the care of our research assistants, which we did a lot. We were really concerned about our students going into the courts, and we really wanted to grapple with that and talk with them through these experiences. And so that was really a deliberate structure of how we did the work. However, I will say that we probably knew this, but maybe didn't give as much structural attention to this as the care for ourselves as well. As Sameena says, we collaborated, and that was a deliberate intervention into this work. But, we also cared for each other through these many, many years of writing this book and working with this material. And a lot of that, I want to highlight that feminist research is slow for that regard, and it's difficult and it challenges the academy that we are embedded in, and is always trying to extract from us as well that we knew we had to, that this was slow. This was a very slow process, and deliberately slow. And I think I know that our work is better for the collaboration. It is better for the slowness. It is better for the time that we took in between things to really reflect. So part of that feminist ethic of care is slow and concern for each other, for our families, for the time together, for the academy, the experiences we've had in the academy, and to share those experiences. And also I'll just add about emotion, really challenging the idea that emotion is analysis, right? That, and again, we often hear about emotion as subjective bias, right? But this is obviously a very huge feminist intervention here, that thinking about how we utilize our emotions in the courts, how we grappled with the emotions of our research assistants and our students to be into the analysis, to guide our analysis, to make our analysis and our findings, I think, much better.
Can I stick with you here, Heather, because I thought, really, really interesting ways you positioned yourself really against sort of a dominant idea within the academy that, you sort of go in, you extract, and you go and you write it, and you're the authority, and you get royalties and those sorts of things. But I'm really struck with something, and I think this was what Gethin was sort of also referring to, and this is why ethnography, because in a sense it feels very intimate, but it's still part of that whole theater. And you do talk about this explicitly in the book, which is one of the things I really liked. So, I mean, Heather, can you just say a little bit more about, this ethnographical approach and why that was so important for this whole project? Because it's also part of the theater that you're also critiquing.
I will say, I think the ethnographic method for us was absolutely essential in that we, and our focus, right? Because our focus was on systems of power. So oftentimes we see so much research on vulnerable or marginalized communities. And while we have that here, we're also what we would call studying up on the systems of domination and the systems of power. And that was particularly important from an ethnographic standpoint for a variety of reasons, not only the work that an archival work, right? Because as we mentioned numerous times, the transcripts don't line up with what we, sometimes they do, right? But oftentimes they didn't necessarily line up with what we had actually experienced and what we had heard with our own ears. And that's really important when we think about historicizing the archival repository that future resources or researchers can go to. You also don't get the gesture, you don't get the emotion, you don't get the performative aspects, you don't get the emotion from participants, you don't see the ins and outs of the everyday practices of a court of law, the good and the bad and the ugly and the horrifying and the joyful sometimes for people who are cultivating a space that they need to work in and survive also every day of their lives. So part of our method really is trying to capture the experiences of people's everyday lives. And I think as April said, what is the day in and day out experiences? What were our day in and day out experiences, and how that can translate into work and research in the feminist ethics that we try to do well by. Sameena, do you want to add anything?
Absolutely. It's such a great question, and I love to talk about ethnography. I teach queer and feminist ethnography now. And, I'm just thinking again, okay, so April asked, like, is it even possible to live feminist ideals and still have a carceral state, for example, right? And where I started off talking about how we had, come into the courts with this method where we said, well, officially the defendant's identity is a matter of public record, right? Analytically, we recognized in the process that this was our own complicity in the carceral state, right? That this was how we were being recruited into this process. And I think you have to be there for that to happen. To again, as Heather says, to follow those emotional cues. So if you were feeling particularly invested, as we sometimes were in a particular outcome of a trial, right? That became a really important point of interrogation, to put that in the notes and to say, like, why am I so invested in this trial going this particular way, right? What is it that I feel I know? And watching the families of the adjudicants react in very different ways to what was happening, again, was quite transformative. The other point I love to come back to again and again is this question of time, right? And this is partly related to Gabriela's points about the different layers of narrativity and narration that are taking place, because one thing that courts do is this on the record talk, like, speaks to an official court record that is actually the addressee there in a felony court in Wisconsin is the appeals court, right? So they're creating a transcript. And what a transcript does is actually flatten time. So one of the cases in the book, there's a great question about, sort of what's the texture of the book. We go, especially in the last chapter, we return to a case that we've kind of talked about over and over again. And we watched this woman, we say it was a marathon of testimony. We watched her for 2 days. The testimony was over 5 hours. The majority of that was pauses or silence or breaks to cry, to breathe. All of that is erased from the transcript. 5 hours over 2 days becomes flattened into 10 pages. There's no commentary in that transcript. And this is also a case in which the defendant's attorney spent a lot of time talking about this woman's red pants. We were like, what is the obsession with the red pants? It keeps coming up again and again. And it felt, desperate. The jury was not like, so she was wearing red pants, so what? Why do you keep mentioning these red pants, right? And he was implying that she was wearing bright red pants because she was a sex worker. This is a really common tactic and one of the racialized narratives in the court, right? But when we saw the trial transcript and the way it comes up again and again, it seems a little bit less desperate, quite frankly, right? And you're not in the space watching the judge controlling their face to not roll their eyes every time the defense attorney says, and, red pants. Why was she out at 3 a.m. in red pants? You're not watching the jury flop and go, oh, this again, right? So there's, a real value in occupying that ethnographic space, because you can see what these different addressees of the narrative are. Yes, it's the people in the jury. Yes, it's the judge. Yes, it's the people in the gallery. Sometimes the families are being addressed or disciplined, oftentimes by the judge, especially during sentencing. Heather and I our presence is marked in a couple of transcripts as well, because sometimes people would say, who are those people with notebooks in the gallery, right? Just one other methodological point is that when you're a socio-legal studies scholar, and when we work from the record, case law, tends to be very specific in that, it's precedent setting. But if you care about power and the way it operates, and we care about the day-to-day of what it means to adjudicate sexual assault in our society, then we need to be able to take a look at precedent conforming cases, right? And this is the other reason why ethnography becomes a really good tool. You can get transcripts again for precedent conforming cases. We purchased them. That was a big part of our grant was, it can be prohibitively expensive. It was much cheaper in some ways once we had the time to observe the cases. But you lose a lot if you just rely on legal records, especially because you will not see, how the day-to-day either remains the same or changes.
That was fantastic and really broadens out the discussion well, because, as you admit, in the book and now, this idea that the positive outcome is in fact conviction. In one sense, emotionally, because we know how difficult that is. We know the barriers. So there is this sense of, everything is stacked up against the complainant. And I was really interested in the way in the book and here as well, this impulse to carceral feminism, which, by the way, I think is the best part of the book, your sort of critique of carceral feminism and this carceral impulse. In the end, though, can you just say what you think is the way forward? Because it is so embedded within our society. And within feminism, carceral feminists, feminism is really huge. What do you think is a better way for society, for courts, for police, for society in general to address these questions?
I will start. That, not a small question. I come to this from a variety of places, I guess. The short answer would be, what can we do? I think we need to listen to survivors of violence. That's very simplistic. However, I don't think that we do it. We may give lip service to it. We may say we are listening to survivors, but frankly, we're not. And I think that our interventions, our hope for the future is to be survivor-led. And that means letting those voices come forward and organizing as communities together. Now, after doing this work, perhaps more solidified in the fact that, and I too, I appreciate all the comments about, can we have is there hope for a rape-free world? Absolutely. I have to hope and envision that and imagine that possibility every day. I think many of us do. I am firmly grounded in the fact that hope is not happening in the court system, in our criminal legal system. That our criminal legal system may be, there may be reforms and things that can happen. I'm not downplaying the feminist interventions of rape law reform. Just because we have those laws and policies, however, obviously and clearly, as we have all talked about, Gethin in particular, that doesn't mean it's happening in practice. And in fact, it's probably quite the opposite. But rape reform or changing rape culture is absolutely not going to happen in this space, because we cannot change. I don't believe that there's great resources we should put into thinking we can change social and cultural or the narratives and the nomos of rape in that space. That space happens outside in our communities and in our families. And I think part of our complicity with this system, because as April says, it absolutely we are all complicit in this. And Sameena and I were able to reflect on that and work together to see our complicity at times, right? As Sameena just mentioned, but it's absolutely important to notice that, to sit with it as uncomfortable as it is, and to understand that our relationship with the courts and with the state, I think, is always non-consensual. And that is the heart of what is happening here. And if we have victims and survivors going into a space that is non-consensual to begin with, then that's the key point and the driver for me. I believe that transformative justice can be the pathway forward here. Part of our complicity as a community and a nation and a global nation is we feel like we have no better options. And we do, but that's going to take a really long time and a lot of community building. And part of white supremacy and paternalism is that it isolates us and individualizes us and makes it seem like we cannot do for self, right? And that's how this ball keeps rolling and rolling and rolling. And so, part is community building. And for me, community building, connections, relationships, and always being survivor-led to understand what indeed are the interventions and prevention and needs of survivors. So for example, and then I'll toss it over to Sameena, is, oftentimes it's not incarceration, right? So, and then the state, this is the case of the state. This is not the survivor that is going forward with some of these cases. And while we think positively on a punishment outcome, or you're going to, we have to remember these are people's partners. It's their husbands, their uncles, their cousins, their community, their families that are being continually incarcerated. And a just outcome may be economic support, right? And when you put someone in prison, that economic support that you need is erased, right? And so we can think of, if we listen to what people need, we can think of a plethora of interventions, I think, right? They are there. I mean, we know they are there. People have told us, but we're not actually enacting them. And there's reasons why, because the state needs to keep operating as it is, to harm and to objectify and, I think, consume us.
Yeah, thanks very much. Let's spend some really interesting comments and questions in the Q&A in the chat here. I just want to turn to some of them, not particularly in the order of which they came, but this one, I want to start with one that actually arises because of what you just said, Heather, and that is that there are these sort of hierarchies of narratives that appear, that are employed in these court situations, and to what extent do they structure as well as sort of create so much of the sort of issue, the problem that you're talking about, and or that the book is addressing?
I can lead off with that one. And I think that one, echoes some of Gabriela's concerns. And so on the one hand, compelled speech means that during any kind of a hearing or a trial, witnesses are only able to respond to questions that are posed to them, right? So it's highly structured in that way. Typically, the prosecution gets to go first, and so they bring their witnesses, and so you have a direct examination, it's called, and then you have what's called a cross-examination. And so I think part of what you have is a narrative structure that comes out of an adversarial, right, justice system, in which we really are, how do we cite cases? They are state versus so-and-so. So I think that structure of an adversarial system in which the burden of proof, right, rests on the state in a criminal case. So they essentially always get the opening, the first word and the last word in this particular case, right? Leads to the types of very disturbing narratives that you hear from both prosecution and defense. Let me be very clear during these trials. And some of this is also, related to the way we restrict what narrative approaches are available. So prosecution, most of the time, has to argue one theory of the case in the US system, whereas the defense, right, to do their job, which is to zealously, advocate for their client, they're basically allowed to throw anything to, what is the charge? The burden of proof, rather, is related to doubt. So they're trying to sow doubt, right? Which is one of these reasons that we completely reject the notion that what's happening in a court has anything to do with reason. You are trying to move the jury, right? You want them to feel something. You either want them to feel certainty or you want them to feel doubt. These may be qualities that have to do with reason, but they sound awfully emotional to me. And the rhetorical strategies that you hear, absolutely are about activating folks on that front. So I don't see a solution in the sense that we are not going to turn our backs on this adversarial system, in part because what Heather and I saw in the courts, which perhaps didn't come across in the description today, is we're in a majority white county, seeing majority Black men being prosecuted for this crime that we know everyone commits, right? So we're already in a space where we're seeing this very particular slice of society that's being disciplined for this one particular thing. So there are reasons that these rules exist, right, to protect the interests of defendants who do come from very, very precarious and marginalized communities, which is why, what we're advocating for, I know it might sound like pie in the sky, but coming to an abolitionist perspective, but it's actually a project that many communities have been engaged in for quite some time. I put a link in the chat if you want to check some of those approaches out, right? And I think the question is what kinds of accountability does a formal court system put into place, and what other forms of holding people accountable for the harms that they commit exist in our communities and can be expanded? Because I think it's very important to remind ourselves that abolition of a carceral system does not mean zero accountability. We have other ways of holding each other accountable. That's what Heather was referencing. So, I do agree that the kind of parsimonious narrative structure of compelled testimony and trial advocacy structures does compel, these particular dynamics, but I think it's also embedded within a set of systems and structures and histories that kind of overdetermine the level of hostility. So that what you hear when I say you hear bad things from the prosecutor and the defense, it's like you hear very racist theories from the prosecution about the criminality of the defendant, and then you hear a different gendered version of that racist screed being applied to the victim by the defense, right? This is very troubling.
Great. In a few moments, I'm going to ask the three discussants just to say one or two words in response to what we've heard today. So April, Gabriela, and Gethin. But before we do that, just very briefly, because I'm conscious that we have about 7 or 8 minutes left, there was a very interesting question in the chat that I just want to hear your response to. And this was a question about the Netflix Anatomy of a Scandal, which actually everyone seems to be talking about. And the person in the chat wanted to know what you think of the trope, whether you've seen it and whether you have any views on it. What do you think of the tropes that it reinforces, how it sort of reflects or does not reflect the realities of the court situation, and does it get anything right? Any quick response about that before I turn over for the last word for the three discussants?
Okay, I'll just really quickly say I haven't seen it yet. I don't think Heather has seen it yet either, but I imagine that it comes in a long line of police and courtroom procedurals. And I believe that same question also posed the question about how do we orient juries to forensic evidence? And we talk a lot about that in the first chapter of the book. And so there is no special training for juries. Wisconsin is a state that does not have grand juries, and some other states where there is a grand jury that might sometimes be called in to decide whether to charge a case. There might be, I've actually sat in on forensic nurses training grand juries, but a jury of your peers, right, is supposed to act based on their common sense. So I'll tell you a story that's not in the book, which is in 2010, I was hugely pregnant and I was called in for jury duty, which was my idea of a great way to spend the day. So I'm sitting in one of the courts, which in fact, I'm like, I think this is one of the courts that Heather and I are planning to study. And we hadn't started the study yet. And in the jury selection, they asked me what I did for a living and I told them. And their question to me was, well, as somebody who has studied forensic sexual assault intervention, would you be able to forget everything it is that you've learned on your own as a researcher and just take direction from what you've been told in the courts? And I told them I would try my best, but that I might not be aware of what it is that I know from my own research and what I pick up on it. I was as honest as possible. I was, funnily enough, not chosen for the jury. But I think that models, again, they really want you to come in with street level knowledge. It's a very 18th century idea of common sense and a jury of your peers. And so what is introduced during the trial is typically often done during jury selection by talking about how different it's going to be from television. It's some of the boilerplate that some of our favorite prosecutors to watch would always use. They'd talk about, oh, this is my favorite television show, and you're not going to see these kinds of things. So there is orienting during the jury selection itself. And we go into great detail about that. But I think we would all love it if the public knew more about the fantasy of forensic science that we see on the television.
Great, thanks very much. Can maybe just a couple of statements from April, then Gabriela, and then Gethin. April, do you want to start us off?
Sure. I will just say one of the things that I feel was really amplified in this conversation, and thank you again for this, is thinking through the ways that the legal archive sets us up, all of us really, to be erased, and thinking through the use of, and I even made a note of it, Heather, you were talking about the ways that you all used emotion as a mode of analysis, and how that really does, when I think about how are we complicit and where do we do that, and how do we address it, those are some of the places where we allow ourselves as consumers of culture, as potential jurors, which I will add to that, Sameena, from the moment I started taking a law class, I've not been selected for a jury. And there was one point in Tucson, Arizona, where I was called for jury duty almost every other month, not selected once. So that idea that we're compelled to be complicit as consumers, as researchers, as the public, and then also compelled to be a witness for the court. It's really amplified and very powerful. And I think an important thing to consider when we think about rape culture and when we think about how to address it. I'll leave it there.
Thanks very much. Gabriela, do you want to make a statement?
Sure. I think what I might say is I'm struck in today's conversation about the role that ethnography needs to play in better understanding court processes, and ethnography as a process of such an in-depth engagement is a particularly costly one, methodologically costly in terms of the time that it requires, the vast amounts of data that it produces. I don't think people who don't do ethnography understands the vastness of the data. I'm always struck by when people talk about big data, and that ethnography is never mentioned as big data because it produces excessive amounts of data that is quite nuanced, contextualized, and cannot be brought in through any other methodological perspective. And while there are plenty of studies of the narratives in law, and those, that's costly in and of itself, I think thinking about the role that ethnography can play in identifying the points at which legal systems are failing, but also points at which we can begin to have some restorative redemptive work.
Thank you, Gethin.
Thanks very much. The difficulty of always being at the end of the line, all the great statements of time. So thank you, everyone. And I'm aware of the time, so two very quick points. Absolutely slow feminist scholarship. More of that, please. And secondly, just read the book. Thanks.
Great. Look, thank you so very much for everyone. Thanks to the panel and also our people listening in for really fascinating comments and insights into this.